Good afternoon, YouTube. My name is Swat Penguin, and this is the second on the constitutional series for Legalese for Newbies. As I said in my previous video, Marbury versus Madison is the cornerstone of all of the Supreme Court's power over the constitutionality of this. And I have my outline. I'm gonna be doing a video about outlining today. Sadly, I can't record things from the computer like I'm doing right now. That said, let's discuss two cases that came after Marbury versus Madison that again started to question, had questioned a lot of what those powers, the power of judicial revision is. And right now, sorry about the bad lighting, I had to fix it later. We're going to be discussing two cases. And both are from Virginia, which is Martins versus Hunter's Legalese and Cohen's versus Virginia. The first one is very important. It's actually one of the more important ones. It's almost as important as Marbury versus Madison because it said that the court before Marbury had the problem that it was really vague. It didn't establish what it could do, what the court could do now. This case actually tells us that the Supreme Court can question the constitutionality of a state court decision in the civil matters. Cohen versus Virginia is the same, only in criminal. What these do establish is that it has the authority to question the constitutionality of those decisions. In this case, and also, it's within the Marshal's court, that because of the supremacy clause, you're going to be reading in the Constitution that the Constitution is the law of the land. I discussed that in the earlier video. This one applies it. These two cases apply the supremacy clause. It says, because all these cases come from appeals or certiorari. I don't know how to pronounce that in English, but in Spanish I'm pretty good at it. Certiorari. I'm going to just say it like that. The state courts alleged that they were sovereign, that they have the power. They did not have to be questioned or abide by the Constitution, whatever the Supreme Court says. Now, the Supreme Court says, and then Martin versus Hunter's Legalese, Marshall does not, he inhibits himself. Why? Because he had an interest in that property, and he knew that if he even dared make a comment about that case, it would be conflict of interest. This time, Hunter's Legalese was done by Judge Stone, and Judge Stone tells us something very important. The states cannot be considered sovereign by the supremacy clause. Why? We're trying to make a more perfect union. Remember those words, a more perfect union. If a state court decides, I am sovereign, it's like treating it like a different country. And right now it would be like treating 50 different countries. Plus all the territories would be considered, for all intents and purposes, as independent countries. And you can imagine how big a mess that could make in making decisions apply. So the court sides with the supremacy clause and dismisses the case. and revokes the decision made by the Virginia Court of Appeals. Cohen's is about a crime. It's about applying that same principle to criminal cases, and that's going to play a lot in matter when we examine cases in criminal law that do reach the Supreme Court, because then the decisions would not be legally binding. Remember, and I will be discussing this later, which is the requirements you need for a case to arrive to the Supreme Court. I don't need to do that if you're already taking constitutional, but it's a good review, because most of these things can actually fall through. It's called, let's see. No. And I have some Puerto Rican cases, but right now this is constitutional, and I don't think it should. But for the benefit of my Puerto Rican viewers, if I do have them, the cases to read in the discussion of the Constitution's power in the court, it's called. The first one is PIP, PIP versus ELA. Estado Libre Asociado. The quote, I don't have it right here, but it discusses what the terms of what majority, what is the majority you need to have for a law to be declared unconstitutional. It's the same principle. And for the record, and this is very important for people who think, oh, I lost in the state circuit, I'm gonna go to the federal court. The federal court does not attend all cases. The Constitution is very strict on that. If you lost in the state circuit, you can't just, I'm gonna go to the federal court and I'm gonna win. No. You need to be in a matter that is discussed in the Constitution. Outside of that, remember, the Constitution is a minimum. The federal Constitution is a minimum of powers and rights it has. You cannot easily assume that just because it's the governing power, it's gonna take all the cases. The basic ones that you will see in federal court and will be taken to federal court are maritime law. Maritime, yeah. I don't know what to say in administratango. Bankruptcy. And any case that the court decides that it deals with a federal matter. That's called campo ocupado. And there's another definition of campo ocupado. The point of the matter is that these are important things. And for the Puerto Rico cases, you should at least check out. Like I said, PIP versus ELA, which establishes that it must be a supermajority to make any law unconstitutional. It has to be a supermajority, which is, in this court, it has to be the half plus one, and that means in a court of 9, it has to be 4 plus 1. It has to be a 5-4. I don't know. I could be wrong. You can correct me in the comments below. The other case is Sanchez Rodriguez versus Lopez Jimenez. That one is, it says that inhibitions and vacant posts are not counted in the votes. And Pueblo versus Bo Nevares. And that one discusses, it's a criminal case, and it discusses about how the Constitution weighs itself. And that's it for the Constitutional series. If you like what you saw, or would you like me to discuss a topic, leave a comment down below. And new content for Legalese for Newbies are every Saturday and Sunday. And I bid you all with a good night, good luck, and as they say in the Hunger Games, may the odds be forever in your favor.